Friends, if you're interested in hearing how we were able to help our client get his 10-year green card after his marriage fell apart very early on in their relationship and things got so messy for him, watch this video because I have some really great nuggets to share with you about how we were able to help our client. For those of you who are new to me, welcome. I'm Latoya McBean Pompey. I'm an immigration lawyer in New York, helping people in many different states and around the world as well. Contact us at McBean Law to learn more about what we do, and also follow me on Instagram at McBean Immigration Law to get more insights and tips from me. Okay, so what happened? I'm so excited that he got through. Let me tell you guys, so excited because I'll never forget when he came to the office and he was at the end of that 2-year green card period, and he was so nervous. He was basically shaken almost, right? He was so nervous because his wife is gone. Things are over, the relationship is over, and he didn't know what to do. And we started working on the case, and let me take you into the presentation on how we were able to help our client in a very difficult I-751 marriage case. Okay, so here's a little backstory on the client. He married his U.S. citizen wife in October 2016, and she filed for him right away. He was actually overseas at the time of the filing. Nevertheless, he got through very quickly, actually, and he got his 2-year green card, the conditional residency card, in February of 2018. And you might be saying, well, why did he only get the 2-year green card and not the 10-year permanent residency card? Well, he got the 2-year because at the time the government approved the wife's petition, they were not married for 2 years, okay? They were under 2 years in the marriage. And so in that type of context, the government only gives the 2-year green card. But then after he got the green card, things fell apart very, very quickly in 2019. And then at the end of December of 2019, he came to us, and he was very nervous, and he wanted us to help him with getting the 10-year green card. And so there's a rule that says that you must file the form I-751 petition to remove conditions on the residency jointly. You must file it jointly with your spouse before the 2-year green card expires. And so this may sound very easy, right? At the end of the 2 years before it expires, file this form with your spouse, right? But for some people, this can be a huge, huge problem, because what if you are no longer with your spouse when you get to that 2-year mark, right? What do you do? And for some people, they're separated but not yet divorced. For others, the marriage may have been annulled. For others, a divorce was filed but not yet finalized at the end of that 2 years. Or the divorce was finalized by that point, or the spouse may have abused the person or the kids, or the spouse is deceased. So whatever the circumstance may be, it can be a very big problem for you if you need to do this jointly with your spouse. And so what we were going to help our client do was to do it on his own. Okay, through a waiver process that allows us to do it, for us to file this on his own. Now, this was a messy situation, right? And you might have facts very similar, right? You know, your spouse may accuse you of some things and places you in criminal court proceedings while all of this is going on. Or the spouse may have blocked you, cut off communication, and you can't get a hold of him or her. Or the spouse tries to take the children away from you. They refuse to file jointly and sign the I-751 with you, or they kick you out of the house. And guys, I will tell you, our client faced all of these messy situations. These were his facts. Now, what did we do? What did we do to help him? Well, firstly, we considered the evidence, right? Because when you're applying to remove the conditions on the green card and get the 10-year green card, the government wants to see a lot of evidence related to the marriage. They want to see a lot of evidence. And in this case, our client actually didn't have a lot. I must be honest, it was very limited. But whatever limited evidence he was able to pull together for us, we explained each and every one of them. We submitted a really good write-up with the case. But I will say that, and then we tried to target the type of evidence too that we knew the government was looking for. And we explained why certain other things were not there. The second thing that we did for him was we appeared at the interview, and we appeared telephonically. And on the record during the interview, our attorney who was present over the phone was able to clarify some issues that came up during the interview. And guys, by the way, I forgot to mention that by the time he had this interview, when he had this interview just recently, the divorce had not yet finalized. It was still pending. And for some of you, you may know that if you go into the I-751 interview and your divorce is pending, that's actually not a good thing. But the divorce was still pending, and the officer said, listen, there's not a lot of evidence here related to bona fide marriage. There's just not a lot of evidence on the marriage side. But we were able to still clarify some issues for the officer, and just having the attorney presence there was helpful in making the client feel more confident. And then this was what nailed it. This is what did it, guys. This is why he was able to get through, because although the evidence wasn't there, we were able to argue another prong, right, around hardship that he will experience if he has to leave the United States. And I will tell you, this is the hardest prong to argue. So the way it works is this: if you're able to successfully prove that the marriage, you have all of the evidence related to the marriage being bona fide and marital unity all the way up until the divorce. If you're able to successfully pull that evidence together, then you're good. They could approve you based on that alone. However, if you don't have enough evidence related to the marriage, you better be prepared to argue that you will suffer extreme hardship if you have to go back to your country. And why? Now, we did this in our write-up. We did argue this prong, but when it came down to the interview now, we needed to do it again and stronger and be very, very vocal on behalf of our client why he would suffer hardship if he has to go back to his country. And so that's exactly what my colleague did. She argued it on the spot. We discussed his ties to the United States, the conditions in his country, and other significant factors related to the hardship that he would suffer if he had to leave the United States. And guys, it worked. And his case, his green card was approved on the spot. The 10-year green card was approved right there at that meeting, and it arrived, came to our office just a few days ago, as a matter of fact. But the case, the notice that I have his notice here in front of me, and the case was actually, USCIS received the case at the end of March of 2020, and then it was approved. This notice date was July 22nd, 2021. So that's what happened for him. So very significant. I just have to just jump back on here just for a moment and let you know that it's super important to have counsel with you, to be prepared, and have that counsel be prepared to also argue hardship that you will suffer if you have to be sent back to your country. And sometimes, guys, sometimes that's what the government needs, right? They need an argument. Not sometimes, actually all the time. They need an argument. And if you don't give that persuasive argument, then the case can go in a very, very different direction. And for our client, I'm really happy that it worked out in his favor. And so for you, if you're out there and you are at the end of the 2-year period with your conditional residence card, contact us, particularly if you're thinking about doing it on your own, if you're no longer with your spouse, if things are really rocky in the relationship. We're good about helping people in those situations, and we could work with you in this situation in any state that you're in the United States. contact us again at McBeanLaw.com for your consultation so that we can learn more and go deeper and advise you about the chances of success and how we may be able to help you with your case. You may also call the law office Monday through Friday, 9 a.m. to 6 p.m. Eastern at 516-866-3900, or email us at info@mcbeanlaw.com, and just say I'm ready to have a consultation, and we'll contact you right away to get that consultation scheduled. Guys, please subscribe to my channel, subscribe to McBean Immigration TV, and hit the notification bell so that you won't miss any of my videos as they come out each week. I hope you found this one helpful, guys. Share it with other people. Thanks so much for being with me, and I will see you in the next one. Bye-bye. Oh, by the way, don't forget to follow me again on Instagram at McBean Immigration Law. See you soon. Bye-bye.